when a client comes to you, obviously client wants a quick relief as soon as possible, right? So how do you prepare your client? Like how do you counsel the client, and and what do you do about it? Because of course clients would want that their problem is gone as soon as possible. But given these restrictions of civil courts, how do you go about it?
See, I'll restrict this answer to the civil law. I will not like to advise here that you file a bogus criminal case just to build pressure. There are remedies available under civil law, depending as to what is the nature of remedy available to you. This is a Order 37 CPC, which has been there since
Summary suit.
Summary suit. You know what does that Order 37 say? See, if you have a prima facie case made out and you have a negotiable instrument which supports it, a promissory note or anything, then you simply file a civil suit under Order 37, which is a summary procedure. The court will issue notice to the other side, asking them to file a leave to defend within 10 days. And unless the other side is able to make that appearance and tell the court that yes, they have a strong defense, they are not able to satisfy the court to that extent, then the court is entitled to pass a decree in favor of the plaintiff. So you get your relief within 10 days or maybe a few months to a maximum. So there are remedies available. Use those remedies. There are remedies available in law with respect to, like I said, the limitations as amended for each procedure under the amendment of CPC in 2002. Simple thing, earlier there a lot of time in procedure we would take place with respect to your evidence. So there was an examination in chief where we would go to the court and then ask the questions, and the steno of the court was going to type the examination of chief. Now, examination in chief was nothing but the contents, basically what the plaintiff has written in the plaint itself. So the amendment of CPC in 2002, they said, why do you need to do that repetition and take the time of the court just to dictate that thing? File it by way of an affidavit with an oath before the oath commissioner. That suffices as examination in chief, and straight away your case can come up for cross-examination. So procedurally also things have changed. Then if it is a commercial court matter, please take it to the commercial court. Again, a lot of limitations have been fixed. Encourage your clients to pre-litigation mediation even before. It doesn't matter if it's a commercial case or not, even in matrimonial cases. Nowadays, there are a lot of times where we advise, and most of the lawyers have started doing that, where they say before going to the court or initiating any action, let's go in for a pre-litigation. Let's go to the Delhi High Court Mediation Center, Samadhan, and get a notice issued. And if there is a possibility of a settlement, we don't need to fight a case. And I'll give you one very practical example here. There is a multinational company engaged me. It was again a landlord related issue. The company was vacating the premises, but for some reason the landlord was not returning the security deposit.
This is a very common problem.
Very common problem. So I was engaged, and this was an outstation matter. So they come to me, they first discuss my fees. It's a mindset, a cultural mindset which needs to change across the country. It's not just the lawyers, it's also the clients. But here was a multinational company, and I'm giving you the mindset of that multinational company. So they call me to their office, they discuss the fees. I take up the matter. They pay me the entire fees in advance. And then they ask me, before you initiate this case, is it possible to settle this? So I initiate a settlement, I initiate a mediation, and interestingly, the matter got resolved in the first 2-3 meetings itself. So I didn't have to initiate a case. The client was happy. They got their refund of the security. I got my fees, and the case got over even before it began. That's the mindset of a multinational client. Same thing in India. A client would tell you, "आपने किया है क्या? अभी तो case भी start नहीं हुआ. Why should I pay you the entire fees?" So they don't realize that they have actually saved on to a lot of litigation cost which would come and they would incur over the period of time. Now that's a kind of a mindset that needs to change, and that can only change with awareness. Awareness what the lawyers can give to their clients, what LawSikho and other institutions like them over the channel through YouTube can give it. That if the clients become aware that they have remedies which can help them resolve it much sooner as compared to a court litigation, then they would themselves want to initiate those, and they would then come to the lawyers with that mindset. So please bring about that awareness and get those cases settled.
Okay, so if you can share some at least 2-3 examples of recent cases where you got some quick results, I mean that would be very illustrative. And
I just gave you one.
Yes.
Matrimonial cases, in a lot of matrimonial cases, they do get resolved in pre-litigation mediation. I think awareness nowadays has come a lot, especially with respect to matrimonial. That yes, why spend another few years litigating? Why not just settle it out? You can get your divorce. Now, simple thing, a divorce, even by way of mutual consent, took a minimum of 6 months earlier. You needed that 6 months between the first motion and the second motion. Now, courts are comfortably, of course, after making an effort, if they feel that there is no possibility of a reconciliation, they are waiving off that 6 months period. So divorce can be granted much sooner, provided you are able to negotiate, provided you are able to talk. Now, why do most of the disputes happen? Why? Tell me. Communication gap. People don't want to talk to each other. They develop that much of hatred. So they come to lawyers. Now what will a lawyer advise? A lawyer will advise them ways to protect their interests. Nothing wrong. But if you get into the mindset of protecting your interest, you will develop the fear more that the other side might be emptying that and protecting yourself.
Right. So communication is not possible.
Communication is not possible. By using these remedies, alternate dispute resolution mechanisms provided to you under Section 89 of the Code of Civil Procedure, you can actually rebuild that communication and get your disputes resolved much faster than in a court of law.
Okay. So how do lawyers balance their interest of, that they have to get fees also, and like you said that, over the longer the case goes on, more the lawyer earns, and if they get a quick settlement, that's a different. So I am asking you from a more practical advice that if there's a young lawyer and they are trying to decide, how should I go about it? So is there the way they charge the fees should also change? Like what do they have to do?
See, fees is something very, very personal. It will change from client to client. It will change from lawyer to lawyer.
Sure.
But when a young lawyer comes, when I had come, I can give you my mindset. The idea was to increase your number of cases because you needed to be in the field. You needed that kind of an exposure. And when a client comes to you, keep that in mind. Very interesting. When a client comes to you as a young lawyer, he has come to you either because he knows that he does not have a winning case. He has tried all the lawyers. He has figured out that he does not have a case. So why not try with somebody who's not going to charge me enough? That is one mindset. And other is that I already have a strong case. Why do I need a good lawyer? I can have a young lawyer. In both scenarios, the client has come to a youngster only with the mindset that he's going to save money. Let him do that. But give your heart and soul to it. Take that exposure, because you as lawyers are officers of the court first. You are there to assist the court. You are not the mouthpiece of your client. You can advise your client if you feel it's a good case or a bad case, and then do your responsibilities well to assist the judge arrive at justice.